Welcome back to the deep dive. Today, we are wading into a truly existential legal conflict.
It really is.
It's a battle for the future of creation that pits this revolutionary new technology against the entrenched gatekeepers of expression.
We're talking about generative AI music.
Specifically, Suno. And we're looking at the RIAA, the Recording Industry Association of America, basically suing them.
Right, because Suno can generate this stunningly high-fidelity, radio-quality music from just a simple text prompt.
It's incredible.
And this isn't just about whether a computer can write a song. It's about whether the entire system we've built to protect creativity can even handle this.
Can it handle the sheer scale of machine learning? Or is it just going to collapse under the weight of its own contradictions?
That's the question.
And that's our mission for this deep dive. We are going to take the Wayback Machine, so to speak. We're starting in 1710 to figure out what copyright was supposed to do.
From there, we'll track how modern platforms and the DMCA completely twisted that original purpose,
Creating this centralized system of algorithmic control that we all know and maybe don't love. Content ID.
which, and here's the irony, created the perfect environment for AI to scrape and learn in the first place. It's a kind of karma.
It is. So then we'll get into the legal showdown with Suno AI, looking at its defenses, fair use, and its vulnerabilities, like this catastrophic risk of overfitting.
There, finally, we're going to explore a potential solution, not a legal one, but an architectural one, a decentralized, protocol-based model called Nostr,
Which is designed to bypass the gatekeepers entirely.
and restore genuine power back to creators themselves. The idea is to uphold the original spirit of copyright, not with platforms, but with code. I'm Satoshi.
And I'm Satoshi. Okay, let's unpack this. We have to start with a history lesson because it shows how copyright, which was born to break a monopoly, has become the tool of a new one. When most of us think about copyright, we assume it's this natural, inherent right an artist has to control their work forever.
Right. Yeah.
But if you actually look at the history, the legal foundation, that idea is just, it's fundamentally wrong.
It's the complete opposite. The original spirit of copyright was profoundly anti-monopolistic. It was all about public progress.
So where does it start?
It all kicks off with the Statute of Anne in 1710. And to really get how radical that law was, you have to look at what came before.
Which was what?
For centuries, it was the Licensing of the Press Act. It wasn't about creativity. It was a tool of monopoly control, built specifically for censorship.
But who held that power? A government body?
No, a private guild. The Stationers' Company in London. A guild of printers.
So publishers, not authors.
Exactly. They had perpetual rights to publish certain works. This copyright wasn't for authors at all. Authors couldn't even be members. It was a right for publishers to control the market, a centralized choke point.
And that broke.
Parliament refused to renew the act in 1694. The monopoly was shattered, and they had to come up with something new.
And that's the Statute of Anne.
That's it. And its goal is right there in the title. An act for the encouragement of learning. This is where we get the famous public bargain, the quid pro quo.
The give and the get.
The give and the get. The whole point was to make sure the publishers couldn't just rebuild their old monopoly.
So what was the bargain exactly?
The statute's genius was all in its limitations. The quid, the thing given to the author, was an exclusive right to control their work. But, and this is the crucial part, it was temporary.
How temporary?
Just 14 years, with a possible 14-year renewal if the author was still alive. So a maximum of 28 years.
That's nothing compared to today. And it was granted to an individual, not a corporation.
A finite, temporary monopoly. So that's what the public gave. Now, what did the public get in return? The quo.
What was the quo?
The non-negotiable public benefit. When that limited time expired, 28 years, max the copyright was extinguished. The work had to fall into the public domain.
For anyone to use.
For anyone to use, republish, build upon. It was designed to be decentralized, replacing this perpetual corporate control with limited, temporary rights for individuals, all to serve that public goal, the encouragement of learning.
So the spirit was fundamentally anti-monopolistic from day one.
Absolutely.
And that utilitarian, public-focused spirit, it traveled across the Atlantic, right? It got baked into the U.S. Constitution.
It did. This is where you see the purpose of copyright explicitly constrained. It's in the Copyright Clause, and every word matters.
Congress is granted the power.
To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
Every single phrase there is a constraint, isn't it?
Everyone. It's not a blank check to just reward creativity. It's a power granted only for a very specific purpose.
To promote the progress of science.
Precisely. And we have to read that like they would have in 1787. Science didn't mean, physics or biology.
It meant knowledge.
Systematic knowledge. Learning of enduring value. That is a critical distinction.
It's why the first U.S. Copyright Act in 1790 only protected books, maps, and charts.
Exactly. Definitive vessels of systematic knowledge. Things that advance our collective understanding.
And this brings us right to the conflict today. The law was built to incentivize an encyclopedia or a new map or a textbook.
Right.
But the automated enforcement systems we use now, like Content ID, they can't make that distinction.
They are technically incapable of it. They can't tell the difference between creativity that yields public knowledge, like a detailed music theory critique, and just simple private infringement.
So it just treats everything as guilty?
Presumptively infringing, immediately stalling the very progress of science the Constitution is supposed to mandate. The enforcement mechanism has completely inverted the purpose of the law.
Okay, so to make sure that this temporary monopoly didn't just stop all creativity in its tracks, the law needed escape hatches.
Exceptions, like fair use. These are the engine of progress, right? They let new learning and commentary be built on top of existing work.
In the U.S., the fair use doctrine is famously flexible. It's an open system.
It is. It's deliberately subjective. A judge has to weigh 4 factors on a case-by-case basis. But the most important one, especially now, is the purpose and character of the use.
And this is where we get the all-important idea of transformative use.
Yes, transformative use is what protects critics, scholars, educators. The idea is that the new work has to add something new with a further purpose or different character.
It can't just be a substitute for the original.
It can't substitute for the original in its main market. So a movie critique using clips to make a point, or an educational video using a song to teach harmony. It changes the work's function from entertainment to instruction. That's transformative.
Now, that's the open, flexible U.S. system. How does that compare to, say, the UK or India?
They mostly use what's called a fair dealing approach. And that's a closed list system.
Meaning,
for a use to be allowed, it has to fit exactly into one of the specific categories written in the law, like criticism or review, reporting current events, or parody. The list is fixed.
And if it doesn't fit, you're out of luck.
You're out of luck. The danger is obvious. If a brand new use case comes along, like, large-scale data mining for AI training, and it doesn't fit neatly into criticism or private study,
it's infringing by default.
Until the legislature acts, which could take years. It's a very rigid system.
Okay, so here's where it gets really interesting. How does this connect to the algorithms?
This is the critical nexus. This is the algorithmic violation. When a centralized U.S. platform like YouTube deploys an automated black box system like Content ID, that system is, by its very nature, a closed-list enforcement tool.
Because a bot can't be subjective.
A bot can't weigh 4 factors. It operates on a binary match or no match based on a digital fingerprint. It can't assess the user's intent or the context. It can't understand purpose and character.
So, in practice, Content ID is technically incapable of doing the job that U.S. fair use law requires.
Exactly. By using this kind of automation, platforms have de facto transformed our open, constitutionally mandated doctrine into a system that's even more restrictive than the UK's rigid statutory approach.
It's platform code replacing public law.
All driven by centralized financial incentives. Which brings us right to the DMCA and how its structure created the perfect low-cost training data set for AI like Suno.
This part is really about the deep irony of it all, the karma, you could say.
It really is.
The major labels and platforms spent 2 decades building this highly centralized, really punitive system of control to protect their old revenue streams.
And that very system, by making human judgment a liability, created the perfect conditions for mass data scraping. It made it the path of least resistance for AI training.
So it all starts with the DMCA, the Digital Millennium Copyright Act.
Specifically, the safe harbors in Section 512. This was back in the late 90s. Online service providers, think YouTube, Twitter, they were facing billions in potential liability from user uploads. They needed a shield.
And the safe harbor was that shield, but it wasn't a right, it was a conditional privilege.
Exactly. And the conditions were the notice and takedown rules. A platform has to act expeditiously to remove content after getting a valid notice.
What?
Here's the kicker. They lose the shield if they have actual knowledge of the infringement or are aware of red flag facts.
And that actual knowledge part, that creates the fatal flaw, the asymmetric risk.
It's a huge high-stakes calculation for the platform.
Okay, break that down from the platform's point of view.
Well, let's say they get a takedown notice.
Yeah.
If they act immediately and remove a user's video, even if that video is totally legitimate, fair use, the platform's liability is almost zero.
And the creator is stuck.
The creator has to file a really difficult 512 lawsuit for knowing material misrepresentation. The legal bar for that is incredibly high. You have to prove bad faith.
Which is almost impossible for an individual creator.
Right. It involves expensive litigation to prove what was going on inside a corporation's head. So most creators they take the takedown, they take the strike.
But what happens if the platform pauses? If they decide to do a human review to check if it's fair use?
Catastrophe. That's the risk. If they pause to review it, a court could later argue that their internal review process meant they gained actual knowledge.
And boom, they lose the safe harbor shield.
For that piece of content, yes. And they face the full force of secondary infringement liability. We're talking potentially billions of dollars.
So the only rational economic choice is to deploy a robot to shoot first and ask questions later.
The law actively punishes the human judgment needed to protect the constitutional mandate of progress.
And this flaw in the DMCA is what pushed platforms to invent something much more powerful than just reactive takedowns.
This is where Content ID comes from. It's proprietary, it's proactive, and it's completely extrajudicial. It's a private legal system.
It's not just reacting to notices. It's a fingerprinting system that scans everything that gets uploaded, often before it's even public.
And unlike the DMCA, which just has one option, Takedown Content ID gives right shoulders 3 proprietary choices: block, track, or monetize.
And that monetize option, that's the great inversion, the insidious part.
It's an extrajudicial tax. That's what it is.
Explain that.
The right shoulder can just start collecting all the ad revenue from the infringing video. They don't have to file a legal DMCA notice. They don't have to hire a lawyer. There's no due process.
And the platform loves this.
Of course. The system is designed to keep their big corporate partners happy, and the platform gets to take a cut of all that ad revenue. It's a win-win for them.
Let's talk about the market consequence here. This isn't really about copyright compliance, is it? It's a risk management and revenue sharing machine for the biggest players.
That's all it is. And it creates a huge barrier to entry. Content ID is expensive. Only the biggest entities, the major labels and studios, can really afford to use it effectively.
So it reinforces the monopoly?
It creates a private court system that's only accessible to the rich. It replaces public law, the DMCA 512, with private law, the match policy, which overwhelmingly benefits the modern-day stationers company.
And this feeds right back into that karma argument. The goal was total control and revenue extraction.
Right.
But by building a system that punished human review, they made it incredibly easy for massive amounts of copyrighted work to be vacuumed up as raw data by AI trainers.
The AI trainers didn't fear the robot because they weren't publishing on the platform yet. The system was blind to the biggest threat it was creating.
And the inevitable result of this whole environment is this profound chilling effect on creativity.
Especially on the very things the law was supposed to promote: criticism, commentary, education.
The system just assumes you're guilty. Guilty until proven innocent.
The penalty is instant. Demonetization, a block. And then the creator is forced into this labyrinth of a dispute process that's just designed to make them give up.
It's a catch-22.
A total catch-22.
Yeah.
The creator disputes it, and who's the judge in the first round?
The accuser, the right shoulder.
Who, predictably, rejects the dispute. So the creator's last resort is an appeal.
And the appeal is the trap.
It is. Because appealing shows you're serious. It basically invites the right shoulder to escalate to a formal DMCA takedown.
Which means a copyright strike.
And 3 strikes, you're out. Your channel is permanently deleted, your entire livelihood gone. So the choice is pay the monetization tax or risk professional execution.
This has to disproportionately harm educators. Like, let's take a specific example, a professional music critic or an academic.
Think of someone like Adam Neely, or a professor from Berkeley teaching advanced jazz theory online.
Right.
They need to use short, illustrative clips of famous songs to demonstrate techniques. It's a textbook example of teaching and criticism fair use.
But the bot flags it.
Instantly, it gets flagged, demonetized, often blocked, because the bot can't tell the difference between a 10-second educational clip and someone uploading the whole song.
And the cost isn't just the lost ad revenue, it's lost knowledge.
Exactly. Without being able to use the work to illustrate their point, their commentary becomes meaningless. So what happens? Systemic self-censorship.
Creators start crippling their own work to satisfy the robot.
They sacrifice clarity. They use a 3-second clip instead of a 10-second one. They spend hours editing and re-editing to appease the algorithm instead of serving the educational purpose. It's a complete suffocation of the progress of science.
I think the most damning evidence that the law has just fundamentally failed is this technical arms race that's emerged.
Oh, absolutely. Creators have essentially given up on the legal argument. They've abandoned fair use.
They've moved on to a technical argument.
Which is, your bot can't detect this.
It's a giant white flag, isn't it?
It is. They use these bizarre technical workarounds, adding subtle white noise, mirroring the video frames, weird audio manipulations, anything to scramble the digital fingerprint just enough to evade the bot.
And the most common one, the one that really shows the triumph of code over law,
is the pitch shift. Raising or lowering the audio track by just one pitch.
It's a compromise. They're not saying, I have a legal right to use this.
They're saying, I have the technical ability to evade your censor. And that signifies a catastrophic failure of jurisprudence.
An entire generation of creators has been trained to satisfy an algorithm, not the law.
They've accepted that the system is broken and found a technical backdoor, which is why the generative AI movement is so powerful. It's a massive, permissionless path around this rigid, centralized gatekeeping structure.
And that path leads right into the biggest legal fight of the decade. So, the RIAA lawsuit against Suno, this is the inevitable collision, isn't it? The legacy control system hitting a technology that thrived on the very data environment that system created.
It was bound to happen. And the whole fight hinges on whether the act of just ingesting massive amounts of data is protected by fair use.
Before we get into the law, we need to understand the tech a little. How does Suno actually work?
It's a hybrid stack. So you have a transformer model, which handles the logical stuff, the musical structure, the chord progressions, the lyrics. And then you have a very sophisticated diffusion model that handles the acoustic texture, the sound of the instruments, the final high-fidelity polish. To get that quality, you need a staggering amount of training data.
Which the RIAA complaint alleges included essentially all music files on the open internet.
That's the key accusation. Massive, unauthorized reproduction.
So the central legal debate is what exactly?
It's this. Is AI training copying for analysis, which is functional, like you or I learning music theory, or is it copying for expression, which is just mass unauthorized reproduction of protected art?
Suno's primary defense, then, has to be fair use, specifically this idea of intermediate copying.
Right. They're trying to place themselves in a line of software precedent from the 90s.
What kind of cases?
Cases like Sega v. Accolade and Sony v. Kinetics. In those cases, courts allowed the intermediate copying of software code. It was a necessary step to reverse engineer it.
To get at the unprotectable stuff inside.
Exactly. The functional elements, the underlying ideas, the interfaces. Things that aren't copyrightable.
So Suno's argument is that they're just catching the audio files as data to get at the unprotectable grammar of music.
The chord progressions, the rhythmic structures, the genre conventions, they're not listening to the files as music. They claim the copying is purely an intermediate step to train a new, non-infringing tool, the model itself.
The model doesn't spit out the original song, it spits out a new one based on the learned grammar.
That's their strongest argument for the input side of the equation.
But the legal ground has shifted recently, hasn't it? The Supreme Court's decision in Warhol v. Goldsmith really weakened the fair use defense for commercial uses.
It did, significantly. Warhol really narrowed the definition of transformative use. It emphasized that if the new work shares the same commercial purpose as the original, the fair use defense is heavily compromised. It looks more like substitution.
And the RIAA is all over that?
They argue that Suno is designed to create music for streaming, for licensing, for ads, the exact same market as the original artists.
Right.
Which suggests substitution, not transformation.
This brings us straight to the fourth factor, market harm. Suno is arguing market expansion.
Right, they had this democratization defense. Suno says their tool creates a brand new market of non-musician creators who could never afford to hire composers or license professional music before.
They're expanding the pie, democratizing music creation, and that argument has some powerful historical precedent.
It does. I mean, you just have to look at YouTube.
Exactly. YouTube started out facing massive copyright lawsuits, a piracy haven. Now it generates over $70 billion a year for creators and businesses.
More than all the major labels combined.
When you democratize creation, you get an avalanche of new work, new jobs, new value that dwarfs what the old gatekeepers were providing.
The RIAA, though, they counter by focusing on the immediate commercial reality. They point to Suno's $24 a month subscription, the fact that it can generate radio-quality music.
They say it's designed to poach licensees and undercut human labor costs.
It's a direct substitution for human session musicians and composers. So the fight is really market expansion versus market substitution. And the outcome will define the creative economy for decades.
Okay, if the intermediate copying defense is Suno's shield, then overfitting has to be its Achilles heel.
It's the ultimate vulnerability, a total deal breaker for their defense.
So define overfitting in this legal context. What is it?
Overfitting is when the AI model essentially memorizes its training data too well. It loses the ability to generalize. Instead of learning the style of music, it just retains and then regurgitates the original expression, sometimes verbatim.
And if the RIAA can prove that?
If they can show, and they claim they have evidence, that specific prompts can make the model generate outputs that are substantially similar to copyrighted hits, then the fair use defense just collapses.
Because it's no longer analysis, it's just unauthorized reproduction disguised as generation.
Right. And it's not just that. The RIAA also has a claim under DMCA Section 1202, the removal of copyright management information, or CMI.
That's the metadata, artist names, license terms.
Watermarks, yes. If the RIAA can prove that Suno knowingly scraped vast libraries while stripping out all that CMI, it proves willful blindness to the legal status of the source material. And that really hurts a good faith, fair use argument.
And what about the guardrails paradox? Suno has filters to stop plagiarism. How is that being used against them?
It's a brilliant legal argument. Suno has these post-processing filters, kind of like a mini content ID, to block outputs that are too close to known songs.
Which sounds like the responsible thing to do.
It does, but the RIAA argues it's a tacit admission of guilt. The very existence of the filter is proof that the model contains infringing data.
Because if it only learned abstract concepts, it couldn't generate a verbatim copy in the first place.
So the filter wouldn't be necessary. They argue the model itself is an infringing article because it retains the ability to generate prohibited material. The technical solution Suno built becomes the primary proof of the input problem.
So while the U.S. case is still up in the air, the international picture for Suno looks a lot worse.
Significantly bleaker, especially in the UK.
Because of that rigid closed list system we talked about.
Exactly. The UK presents a massive headache for any commercial AI company. Their only statutory mechanism for large-scale data ingestion is the text and data mining, or TDM, exception, Section 29A.
And Section 29A has a fatal flaw for Suno.
A critical exclusion. It strictly permits TDM only for the purpose of non-commercial research.
And Suno is very much a commercial enterprise.
With a subscription model. So they categorically cannot rely on that exception. The UK government, after intense lobbying, deliberately chose not to expand it to commercial uses.
So Suno has to fall back on this server haven defense, arguing that all the training, all the copying happened on servers in the US.
Right. They argue that under the principle of territoriality, UK courts don't have jurisdiction. But UK courts have been very aggressive in collapsing this defense. The vulnerability for Suno is secondary infringement.
Meaning the model itself is seen as contraband.
If a UK court decides that the model weights, the file containing the AI's brain, are an infringing derivative work because they contain compressed copies of copyrighted data.
Then just making the model available to UK users is like importing illegal goods.
Precisely. They don't have to prove the copying happened in the UK, just that an infringing product is being distributed there.
And there's also the tune-in precedent.
The tuning case is key. It established that an online service that targets UK users can be liable for infringement, even if the transmission comes from abroad.
So if Suno has UK pricing or UK-centric ads,
they can be found liable for communicating the underlying musical works to the UK public, completely sidestepping the territoriality defense. It's a big problem for them.
And what about India?
India is more of a gray zone. They also have a rigid, closed-list fair dealing system, and the exception for research historically excludes commercial research.
But the courts are sometimes more flexible.
They have shown a willingness to import U.S.-style transformative use principles. There was a case, Chancellor Masters, involving a guidebook for a textbook, where the court said the guide served a different transformative purpose.
So there's a hook for Suno there. They can argue their model is a transformative tool.
They can, but the commercial nature is a huge barrier. And India has very strict intermediary liability rules. Relying on judicial activism to create a commercial TDM exception out of thin air is a very, very high-risk strategy.
So it's clear. The centralized, platform-controlled systems created this mess. When the law is too rigid and compliance is too expensive, innovators are always going to find a cheaper, permissionless path.
The legal problems are just symptoms of that architectural failure. The censorship, the fear, the inverted burden of proof, it all stems from the centralized walled garden platforms. If you can just decouple the creator from the platform's coercive power, the whole problem changes.
Okay, so we started with the idea that copyright was originally anti-monopolistic. We showed how centralization inverted that. We analyzed the legal crisis that resulted. So if the failure is architectural,
The solution has to be architectural. That's the core thesis. We have to move from depending on platforms to trusting protocols.
decentralized open protocols are the only way to break the platform's coercive power, the power that comes from owning your identity, your content, and your revenue.
And the protocol we're going to focus on is Nostr. Notes and other stuff transmitted over relays, because it addresses the root cause of the power imbalance.
It solves the dependence.
The dependency that fuels the culture of fear. Let's just look at the three core primitives it provides.
First up is identity. On YouTube or X, my identity is an account that can be deleted if I get 3 strikes.
On Nostr, your identity is sovereign. It's a cryptographic key pair, a private key and a public key that you generate yourself and you own. The private key never leaves your device.
So you can't be deleted, you can't be deplatformed.
Exactly. Even if a specific relay, one of the servers, decides to censor you, you just tell your client to connect to a different relay. Your identity and your audience follow you. That dependency that fuels the fear, it's broken instantly.
Okay, primitive number 2. Content verification. This sounds like the direct antidote to Content ID's opaque black box system.
It is. It's NIP94, the file metadata standard. Content ID uses a private, proprietary fingerprint to block things. NIP94 flips that on its head. It uses a public transparent cryptographic SHA-256 hash of the file itself.
So the file's unique digital signature.
Yes. The X tag. It's an immutable, verifiable address for that piece of content. This inverts the burden of proof. The hash proves, publicly, that the content hasn't been altered. A centralized company can't just claim a match based on some secret fingerprint.
And finally, value. We need a way to restore that quid pro quo directly between 2 people with no middleman taking a cut.
That's NIP57 Lightning Zaps. It's a programmatic, non-custodial micropayment system built on Bitcoin's Lightning Network. The key part is the Zap receipt.
How does that receipt work as a verifiable proof?
It's a 2-step system. A client sends a Zap request, and when the payment goes through, the recipient server publishes a Zap receipt, a kind 9735 event, to the public Nostr relays.
And that's permanent.
It's an immutable cryptographic proof of payment permanently on the network. It proves, without needing a bank or a platform, that value flowed from the sender to the recipient. This is the verifiable quid that's totally missing in the centralized demonetization-based system.
I have to challenge this, though. Content ID, for all its flaws, generated billions for the labels. How do you get them to adopt a system that relies on micropayments instead of massive ad revenue? And isn't this just shifting the enforcement burden onto the individual creator?
That's the essential trade-off, and it's why this is an architectural fix. The current system extracts billions by forcing everyone into a centralized ad model and imposing a huge compliance cost on creators, the chilling effect.
Right.
Nostr replaces that centralized profit motive with direct, efficient compensation. And yes, the enforcement burden does move from opaque automation back to the explicit definition of rights, which is where copyright should have been all along. The creator defines their terms, and the protocol automates the enforcement of those terms. It's moving from automated censorship to automated permissionless licensing.
So the core problem with fair use is its ambiguity, which these centralized systems exploit. This policy tag proposal for Nostr is designed to kill that ambiguity.
Exactly. It allows creators to define explicit machine-readable policies for their work. You're basically encoding your own fair use acceptance criteria.
You're moving from platform-defined censorship to creator-defined, machine-readable rules.
Let's walk through how it would work, step by step, using a new policy tag.
Okay, let's take our musician again. They publish a song on Nostr using NIP94. It has its verifiable hash.
Then, in the metadata, they add this new structured tag, for example, policy, criticism, 500 per minute. This explicitly states 500 satoshis per minute for criticism, payable instantly to my public key.
And they could set others, too.
Sure, they could add another one. Policy, non-commercial, 0, peruse. Free for non-commercial use.
Okay, so now our music critic wants to use 2 minutes of that song in their commercial educational video.
Their Nostr native video editing client reads the song's metadata, sees the policy for commercial criticism, calculates the cost 1,000 sats for 2 minutes, and automatically executes an NIP57 zap. The musician is paid instantly and directly.
And this solves the verification problem.
Perfectly. The musician gets the payment, their server publishes the zap receipt, the cryptographic proof of payment, and the critic's new video embeds the event ID of that zap receipt in its own metadata.
So the license is baked right into the new work.
It's an immutable public license. If some automated system were ever deployed against this new video, it would instantly see the verifiable public proof of license and know that the takedown is invalid.
And what if the creator changes their policy later?
The zap receipt is immutable and time-stamped. It serves as proof that the user complied with the policy that was in effect at that moment. The license remains valid, protecting the transformative work forever.
This sounds like it restores the quid pro quo to its original anti-monopolistic spirit.
It does. The creator gets their quid a direct, instant micropayment. The public gets its quo, the transformative work that promotes the progress of science, now with a public, verifiable proof of license. No need for expensive lawyers or opaque content ID filters.
And this connects directly back to that idea of democratization. The fight over Suno is really about access. When the gatekeepers make creativity too expensive, innovators will find a permissionless path.
Whether that's training an AI on scraped data or building a protocol that bypasses the gatekeepers entirely, the result of that democratization, as we saw with YouTube, is an avalanche of new work and new value. The protocol solution just future-proofs that progress.
So we started today by exploring how centralized platforms, acting like a modern-day stationer's company, completely inverted the anti-monopolistic spirit of copyright.
They use the DMCA as a shield to automate censorship with Content ID, creating this culture of fear that punished fair use and, ironically, created the perfect feeding ground for mass AI scraping.
We saw that conflict explode with Suno AI, where the entire debate now hinges on these high-stakes concepts like intermediate copying versus market substitution.
And the success of something like Suno is, it's arguably the predictable karma of a system designed to penalize creation and incentivize control.
The struggle over AI is forcing us to see a deeper truth. The legal problems we have are just symptoms of an architectural disease centralization.
Which means the solution has to be architectural too. Decentralized protocols like Nostr eliminate that dependency. They replace opaque censorship with transparent, automated licensing, and they restore the original bargain of copyright.
The legal struggle over AI and creativity is forcing us to confront a deeper truth. When knowledge dissemination is too expensive or too controlled, creators will always be forced to seek decentralized, permissionless paths to share their work, effectively rediscovering the original anti-monopolistic spirit of the law through technical means. The question for you is, are you ready to move from depending on platforms to trusting protocols?
Thanks for diving deep with us. We'll see you next time.